welcome to another instalment of Outer Temple Chambers Travel Talks. I'm very pleased today to be joined by Cheryl Palmer-Hughes. Cheryl is a partner in Irwin Mitchell's International Serious Injury Department, as well as the chair of the PEOPIL Young Lawyers Group, an international practice group member of the AAJ, and a Manchester Law Society Council member. Today's focus is going to be on expert evidence in cross-border cases, an area in which Cheryl has considerable expertise, and focusing more on the practical issues of expert instruction. So to start off, Cheryl, what's your general approach to instructing an expert in a cross-border matter?
Thanks, Ian. That's a very wide-reaching question. In terms of where do we start if we're thinking about a cross-border case, then we want to look at eventually what evidence the court's going to need in order to establish liability in favour of our client. And then there are a number of considerations that we need to go through in terms of actually selecting an expert, which expert. So there are a lot of experiences that we can draw from. So we can think about experts who have reported in similar cases before, experts who have reported in cases but for the other side before, experts who have appeared in court judgments that we've seen, people we've been introduced to, people who approach us, or in some circumstances we don't have any known experts and we have to go and search and find somebody who might be suitable for what we need.
So kind of going through those in turn, the ideal situation and whether or not it's going to be an applicable law report or a local standard report is going to be the tried and trusted expert who you've seen reports from, you've seen them in trial, but there's going to be situations which we both come across a lot of times when either that expert's not available or you've got a case in a novel area and you're searching for that new expert. So in those cases where you're on the search for an expert, and perhaps you've never come across that expert before, what kind of factors are you taking into account? For example, do you ask for feedback from maybe other people in the industry, or maybe do you even ask for draft reports from those candidates?
Yeah, those are good examples of the things that we ask for. Feedback or referrals from colleagues, even people that we know through networking who we think might have a good contact. Speaking to somebody who has worked with an expert before is always really helpful if you haven't personally instructed them. How
important would you, for example, say language skills and perhaps promptness and issues like that, attentiveness, would be in terms of being an appealing factor for an expert?
Those factors, I think, whether you actually know an expert or not, are absolutely crucial, especially in cases that we are running in the English jurisdiction where they're going to be subject to quite strict timetables and cost budgets. It's absolutely crucial that the person that you are instructing is responsive, that they are aware of the timetables in place or expectations of the client. One of the primary considerations whenever I'm introduced to somebody, either if it's through a referral that somebody knows or if I've gone to find an expert who I've never worked with before, is actually how they're going to come across in court. And there are lots of different factors that play into that. One that we come across often in these cross-border cases is language. Do we need somebody who is able to give evidence in English as a second language? Or is it that the case could carry the cost of having translations? And that's an important consideration, not so much in terms of whether the expert is able to produce a report on the area that we're asking a report from, but in terms of the practicalities of the case. Have we got enough time to get a report and then have it translated? So those practical points in terms of communication, responsiveness, and overall appreciation of what it is that the court will need from that expert. I often, even if I'm referred to somebody who has worked with a colleague or a contact of mine, it's a good idea to have a preliminary chat with the person that you're going to be instructing. Then you get a sense of experience in these sorts of cases before appreciation for what is needed, and then you can then guide them in terms of how much information you need to include in your instructions, and you also have a feel for how they might present a report.
Do you also think it's quite important for experts to be realistic with regard to the extent of their knowledge of English? I mean, we'll often find that some experts are maybe perhaps very good at conversational English, but they may feel as if they'd struggle in trial, or perhaps their written English may just be a little bit more awkward, and perhaps there can be the benefit to them, maybe although they're perfectly fine on the phone speaking English, better producing their reports in their native tongue than having it translated.
I think so, and I think that's a conversation that you can have with the expert. I think, again, a practical consideration, if you are speaking to somebody for the first time, if they're speaking to you in their second language, that might not necessarily be how they are able to communicate and convey their points in the future, because that might be it could be a high tension meeting, or it could be a bit of stress there, or a bit of nerves. But I think it's important to be open about what our expectations are and what it is that we can deal with. I think an important point is that we don't necessarily need somebody who is an expert in a very specific area that we're looking at, as well as effectively being a linguistic expert. We're not bothered about a linguistic expert. What we want is an expert on the point that we're looking at for the case. And we just need to know on a practical level whether we're going to need translations or not. And I think being open about that and not having your expert feel that they have to give evidence in English is a really important preliminary point to discuss with them.
So that's certainly something where you would be inviting an expert to be quite candid about their language skills at that point. What about reviewing an expert's qualifications, or perhaps even professional memberships? Would that weigh into a consideration as to whether an expert might be appropriate or not?
Absolutely. It's multifactorial, really, and you've got different experts for different scenarios. And I think one danger in working with experts in cases such as these is the assumption that you can have the same expert for a number of cases based on country. And I think it's really important to take it right back to the start and look at what it is that we need evidence on, what specific point, and see who's got experience in that. And you can only really glean that from people's CVs and talking to them about, not just about qualifications, because academic qualifications, if somebody's based in a different country, they might not be tangible to you. So maybe a conversation, well, what does that actually mean? What did you study? Was it a practical course? Was it a theoretical course? And then beyond that, the usual questions that we would ask the Part 35 experts in terms of experience at court, who have they been instructed by, what points have they reported on before? And again, it's similar to the language point in terms of whether this expert has sufficient knowledge of the specific area that we're looking at. And I think we invite candor in terms of whether they have dealt with that specific issue before, whether they have dealt with a similar issue in slightly different circumstances, and just take the time to explore that with them, and then you're aware of what the remit of their knowledge might be. And as a side note, I think it's fair to say that we should be cautious about those experts who say they're experts in absolutely everything. My personal view is it's going to be quite a rare case where somebody can report on building standards as well as voting regulations or food hygiene, and all of those things together, I think, warrant specific areas of expertise.
And would that weigh into a factor as to whether or not you would, generally speaking, prefer your expert to be based in and qualified in the country that you're focusing on, as opposed to, for example, an English-based expert who may have some knowledge of the country, or maybe speaking to local lawyers, researching that issue and effectively producing a report which has effectively second-hand information based on the expertise of others?
I think that it's very important to explore what it is that your expert is going to report on. I think the question of whether they need to be based in the country where you are, where the accident occurred, is very case specific. I hesitate because all of our cases are so varied, and the factual matrix behind the need for a report, you rarely get two scenarios that are exactly like each other. And so I think we do need to carefully consider what it is that the court will need at the end. And I think the different solutions that you've mentioned and summarised there may well fit different types of cases. The types of cases that I see, our preference would generally be to liaise with both a lawyer and a technical expert. That way, my view is that you have covered all ground, and it might be that you have preliminary discussions with them at the beginning, and later down the line, then you consolidate the views as to actually whether you need a full Part 35 report from both of them, or as you say, whether you can combine it. I often find that our colleagues in other countries are able to help us source the technical experts, and so those relationships are key in terms of identifying somebody who can help you with your specific issue. There are occasions where we instruct people, experts who are based in England, who might have a wider reach in terms of their expertise. To be honest, those cases are less frequent, but it does happen where actually you can't find an expert locally. If you're talking about a very small community or a very small island, for example, the expert you need simply might not exist. And I think in those situations, it's very important to think pragmatically and laterally about actually how you might get this evidence before the court in those circumstances. Maybe not even an English expert, but maybe somebody in a neighbouring country who sees people travelling between the two might have some experience. But again, you've got to think quite practically. There is no formulaic approach to these instructions to experts.
It seems to me that fits in with an example of a hearing that I had in court recently, where you have the classic slip in Spain. You usually have the lawyer giving evidence with regards to system, and the lawyer can sometimes give evidence with regards to the quality of flooring in Spain, usually the three-step system. And then sometimes you may well be going to a Spanish architect who might be able to advise on that issue. But for example, there'll be no difficulty with an English expert perhaps commenting upon what the actual construction of the floor is and what its slip resistance is. It all depends on whether or not it's reporting, I think more on fact or local standards. And it's usually the local standards where the locally based expert tends to be preferable, I tend to find. Moving on to assessing, continuing in the field of looking for an expert. What benefit do you find that you gain from networking in terms of either finding experts or maybe sussing out what an expert might be like in conference or at trial?
In terms of finding expert, I think the networking can be useful on at least two levels. You might be networking with people who could actually report for you, in which case you've got a direct introduction, and in a networking scenario, you will probably have the opportunity to explore experience, the type of work that they undertake normally. I think it's important not to lose sight of the fact that where we are speaking with people, for example, foreign lawyers, what we would ask them to do for the English court is very different from what they would do in terms of format from their home courts. And so an informal discussion actually about what the relationship could deliver in terms of instructions and what we would expect. And that can be a direct conversation that you have with somebody that you meet. Alternatively, it might be that you meet somebody who has contacts and they're able to share them with you. And when you meet somebody who can be that intermediary, again, an exploratory conversation in terms of what cases they've worked on with these proposed contacts, what type of reports, what type of relationship it is. Because, as I say, simply because somebody is a lawyer in a foreign country or a technical expert doesn't necessarily mean that they will deliver the reports that we need for our courts. In terms of networking and its advantages for getting to know the people who might be preparing reports for you, I actually think this is one of the biggest benefits of networking. You get to directly communicate with a person who could further down the line be communicating to the judge and to the court. Through conversation, you will get to know their experience, you'll get to know their communication. You'll get to know a little bit about the culture and the environment in which they are working, because that is often very different from the environment that we're working in. And not only is it important that somebody we're instructing appreciates the timetable that we're working to and the cost budgets that apply, but also if we can have an appreciation of how they work, what their caseload is like, how responsive they're likely to be. We can actually take that into account. We're not talking about changing people's working practices. We're talking about an appreciation. You can then convey that to your clients, and you can manage your client in terms of responsiveness, how long the report might take. And all of those practical considerations that we discussed earlier, you can explore those very, very efficiently in a networking type scenario.
And I'm certainly aware of colleagues who work in Europe, particularly in law firms, similar to solicitors in this country, who will either act on one side of the fence for claimants or defendants. Now, do you think that perhaps a claimant lawyer in France would be precluded from working on defendant cases and vice versa, in terms of offering expertise on that law? One claimant lawyer in Europe who has said in an email that they don't want to do work for a defendant because they believe in the claimant cause. Now, my view is that probably wouldn't be too compatible with Part 35, and if that information was disseminated, that perhaps could perhaps even cause a claimant lawyer concerns about using an expert who says that, because of course their primary obligation is to the court, not to the party who's instructing them, and certainly not to take an ideological view on the case. So I'm assuming that might be something which could raise an alarm bell if you saw something like that.
Absolutely. I think we've got to go back to the overriding objective, what the Part 35 expert is there to do, and again about those conversations about what it is that we are asking of our expert and what the court is expecting of them, because a partisan approach, for want of a better term, doesn't nicely and neatly fit in with an expert's objectivity.
Good. It just goes to show the issues that you've got to be careful of, and the fact that Part 35 obligations really do need to be clearly explained to experts, and experts who've got an understanding of Part 35 really are much more useful when it comes to this kind of work, aren't they?
Absolutely. Sure.
Right. Well, that's concluded our focus in on selection of experts. That brings an end to this episode of the vlog. We're going to come back focusing on more practical aspects to expert reports.